Yeah, each one has been taken care of in 90 days. But they both on
I'm so sorry. It's okay. I'm sorry, what'd you say? You want me to start from the beginning? Scared everybody.
Yeah, each one has been taken care of in 90 days. But they both on
I object. This is not the incident in its entirety. This is not even what transpired. Yes, this is not no injury. This is not even where the person injured me or anything. I object. This is it happened. It happened there. Not this is not the pit. This is not what it was. You don't see nobody injuring me or nothing. Me getting hurt. So how did? Sir, no, that is not what happened. I object. This is not it. I object to it.
It was exchanged in Dropbox. It was properly submitted.
Sorry.
It goes towards the weight. We're not talking about invisibility right now. It goes towards the weight.
Objection. I'm just objecting it. It's irrelevant. It's not the evidence. It's not even the evidence of what transpired.
Objection is noted. Once we're on the record, you can make your objection then.
Okay, well, I'm done. This video shows not the injury. The person injured me going to the hospital. The people coming out or nothing. Objection to the objection.
Okay. They will be noted when we go on the record.
This was no incident. Nothing happened on that video.
Like even in here?
Mr. Young, there's no other videos that...
No, that's the
okay.
only other. That's the only
Okay, then
video.
no. I can log out.
Boy, it's a dirty game.
Stacey, you already have your copy, right? 'Cause
Correct.
I gave her mine. Okay.
Thank you, Dee.
Objecting, go through the remainder of my exhibit list, Judge.
Well, are we on the record?
No.
No,
Okay.
We're getting organized.
I want to make sure that it's fresh, that what I'm objecting, it has no date, no incident where things transpired, or person, or police, or security, or supervisor. Nobody that was there, that video was not the proper video?
There is a date on the video, Judge, just so you know.
Okay, the time, the police. Okay, where are the police? Where is the Metro's supervisors, managers? Where are the things that transpired if that was the injury, when I got injured, sir? That is irrelevant and not even proper evidence of what transpired.
Judge, whenever you're ready, we can go through the remainder of the exhibits.
Yes.
Because you matter and what I say don't.
The accident video is Exhibit 1. Exhibit 2 is the signed affidavit from Keisha Beck regarding the accident video.
I'm sorry, excuse me, from who?
You have
Everything's in front of you, ma'am.
the exhibit list we're going through is the top page.
Unlike you, I prepared an exhibit list. So
As you should, you've been a lawyer for 30
Mr.
years.
Young, what's time?
But do illegal.
So Exhibit 2 is the signed affidavit of Keisha Beck regarding the accident video.
Who? I don't know who that is. I object that objection. That person was not there. They have no relevance of what happened.
And that affidavit is being submitted, Judge, pursuant to Section 490.692 of the Business Section.
Okay. Objection, no relevance. Was not there.
You can object to it on the record.
Oh, okay. Y'all just going through it? Oh, I could just wait then because I'm going to object whatever doesn't pertain.
Yeah, I only have the 7 exhibits that are listed there, Judge.
Okay, that's
let's
fine.
keep going. And then,
Also have the 60-day letter regarding the medical records from Dr. Kraus, along with all of the medical records from Dr. Kraus. I also have the 60-day letter on Exhibit 4 to claimant regarding the medical records from Dr. Hinton, which, by the way, it's important to note Dr. Hinton was the doctor that was that one of her first attorneys sent her to, was Dr. Hinton. That was not done at my request. That was done at the request of her attorney. Exhibit 5 is the 60-day letter regarding the IME report from Dr. Nagalski. And 6 is the affidavit of Tracy Tate regarding the TTD and medical payments logs. And then there are the attached TTD and medical payment logs. And again, that affidavit is being submitted pursuant to Section 490.692. And then Exhibit 7 is a transcript of the claimant's deposition from July 6th of 2026.
thank you. Okay, let's begin. Once we're on the record, I'll summarize the exhibits. We're only discussing the work-related injury today. All the other assertions of any emotional distress, workplace conduct, discrimination, I will not consider them. They're outside of this court's jurisdiction.
So that means you're alleviating the sanction because the sanction was on my civil lawsuit. So we're not discussing that today. Because you put in your email sanction pending, but you can't.
Lawyer sanctions.
Right, but it was for my civil lawsuit, and that's illegal to intimidate, retaliate, or bully me for a civil lawsuit. That's what his sanction was for, sir. So if you're saying you're only privy, be young, 2 sanctions for a civil lawsuit.
There have been no sanctions entered on this.
You said you were pending. You said you were pending
Yes,
it.
The sanction on you using fictitious citations.
On a civil lawsuit. It has no grounds.
Okay, well,
How are you?
To the final hearing, I will make my.
So how are you prolonging his unethical behavior for a civil lawsuit, but you don't want me to mention none of the unethical behavior that happened in my workman's comp that is workman's comp? That's not fair or just. 2 sanctions were filed for a civil lawsuit for him stalking me, and you're gonna make that pending for a civil lawsuit in workman's comp.
Only sanctions that have to do with 287 and 8 CSR 20. And if they're not, then I will not review them.
They shouldn't even been presented. So are they pending or not? Because it has to do with a civil lawsuit.
Terminations after we get off when I'm writing my final award.
For a civil lawsuit? But you said you didn't want to talk about that. But that's the sanction.
We're not talking about that.
But it's part of this.
Judge.
Right, that's what I'm saying. He's going to bring it up.
What's relevant is that in her email to you, to me, and I've outlined it in my motions before, she attached a document, which I have a copy of it here, called Complaint to the State Bar of Missouri.
I sure did.
She filed that with STL Docketing. She emailed it to you. She filed it with, I believe, with Jefferson City as well. She filed that document, and it is in that document, in an attempt to persuade you in this workers' compensation claim, it contained false case law. That's the
No, I did not, sir. No.
Well, it'll be ruled on at the.
No, I did not. You said.
If that brings it back under 287, then it will be ruled upon then.
It's a civil lawsuit. It has no grounds in this.
You're talking
Workman's
about
comp.
what's being referred to and not the actual motion.
It doesn't matter. It has anything civil law. He has no right to look under. I got verbatimly. I can prove that he verbatimly said he referenced my civil lawsuit, and in the means of him looking in my civil lawsuit, he saw that I utilized case law that had been not case law, and that's the grounds of what he wanted to sanction on, for me to pay him and pay for the whole workman's comp endeavor, which never should have went any further. It should have been shut down, but you have it pending and saying that it falls under certain criteria that are not even legal within workman's comp. Then Sarah Server, who reached out to you, at least that's what she said, she reached out to you in the courts, said that you guys have not dealt with anything pertaining to my civil lawsuit or any paperwork filed in my civil lawsuit, which she sent me a letter stating that you guys already said my civil lawsuit has no standing in workman's comp. But they could not be just if he has two sanctions, and that's the only basis that he filed his sanctions on.
Your civil lawsuit standing in civil court and our ability to hear it when used within filings in the division under 287 are two separate things.
I didn't utilize it with filing any. I never brought it up to you. I never utilized it. He did. How can he go bring up something else?
If you want to make a note of this.
He did not receive an email about my civil case.
We're not going to talk over each other. One at a time.
I don't like lies.
You received an email on January 28, 2025. It was sent to you. It was sent to STL Docketing. It was sent to. It was also sent to Stacy, and it was sent to Dawn Brunson. And in that document that was filed through STL Docketing contained, and I've got a copy of it here if the court wants to see it. It was entitled Complaint to the State Bar of Missouri. Now, it was in that document that contained the fictitious case law that was filed through STL Docketing and emailed to you again on January 28 of 2025. I submit then, and I submit now, that was an attempt to use fictitious case law generated by AI as an attempt to persuade the division.
Okay, so I object. First of all, how do you know it was AI? How do you know you can't keep allowing him to? How do you know it was AI? Second of all, I have been told the courts that my paperwork has been being altered, which I also have the paperwork with the court orders that have been altered too, to prove that paperwork is being altered, which he probably would know about since he knows everything I'm doing and saying that he's looking up everything and I'm using AI and I'm doing all these things that are not even privy to the court and have no relevance to the workman's comp, which is abusing his authority. But I have proof that my computer, my phone, everything has been compromised, which you, Your Honor, have been addressed about this. And he would know if he is privy or part, and I believe he is, to me being compromised. It has my civil lawsuit has no relevance to workman's comp, period. And anything that he wiggled or finessed his way in has nothing to do still with workman's comp. You can't penalize me or punish me for utilizing civil litigation outside of this court. And that is ridiculous. And under them orders and motions, they only apply to workman's comp. And the civil lawsuit, if he feels that way, he can apply for within the civil lawsuit. But I'm pretty sure they're going to not give him no standing because he's not relevant in that case. Whatever he sent you or said that I sent, it was not privy to workman's comp other than if I submitted a complaint. Everything else is irrelevant, and things have been altered, and I have proof that they have been altered.
Can we proceed, Judge?
We may proceed.
Because what I say don't matter.
Before this testimony begins, I'm going to remind both parties no personal attacks, no outbursts, we're not talking over one another, and do not attempt to introduce topics or evidence already excluded. And Ms. Jordan, you will be allowed to testify fully on the record. If you interrupt or disregard my rulings, I will issue a warning, and continued violations will result in either party's removal and the record being closed and me making my ruling based on what has been submitted to the record at that time. And I have statutory authority to do so. Let's go on the record.
Can you? Why did you just specifically say my name when it's two people that you have?
Parties.
You said Ms. Jordan. I don't know if you know that.
Ms. Jordan, you will be allowed to testify because as you are representing yourself, I just wanted to be sure to inform you.
But you didn't mention him as far as the rest of the stuff.
He's not testifying on his own behalf.
But what does my testify have to do with you
Because
saying
you're
that
the
you would
party.
cancel my case?
No, I'm saying if there are continued outbursts, we're going off the record. And it's starting now. Let's go on the record. We are on the record in injury number 22-024755, Neiman Jordan v. Bi-State Development Agency. This is a final hearing before the Missouri Division of Workers' Compensation to determine the extent of permanent disability resulting from the accepted April 14, 2022 right ankle injury. Will the defense please state their appearances for the record?
Sure. J. Perry Bradley Young, and I represent Bi-State, the employer insurer in this matter.
Thank you. Ms. Jordan, would you please state your name for the record?
My name is Naima Jordan, and I am the plaintiff that was injured, or complainant that was injured.
Thank you. The court reporter is Stacy Benoist. Today is Thursday, April 24th, and the time is 2:30. As the party is acting pro se, Ms. Benoist, I would ask you to please swear in Ms. Jordan as she will be testifying on her behalf and as her representative herself.
Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Let the record reflect that Ms. Jordan has been sworn in as the pro se. This hearing is limited to the sole issue of whether Ms. Jordan sustained permanent partial disability as a result of the accepted work-related injury to her ankle on April 14, 2022. All other issues, including allegations of retaliation, harassment, discrimination, or emotional injury, have been dismissed with prejudice by prior orders. They are outside the jurisdiction of this division under 287.110 RSMO, and they will not be addressed here. This hearing is governed by Chapter 287 RSMO and 8 CSR 20. As the presiding judge, I retain authority to conduct the hearing and make inquiries calculated to best ascertain the rights of both parties. Ms. Jordan, although you are representing yourself, you are required to follow the same rules and procedures as a licensed attorney. This includes the timely exchange of evidence, observing courtroom decorum, and making only legally recognized objections. Objections must be concise and based on legal grounds, such as relevance or hearsay. If they are sustained and overruled, we will move on. I can note them as well and take them up on record later under advisement. All evidence and testimony today must directly relate to the April 14, 2022 accepted injury and the extent of any resulting permanent disability. Anything beyond that is outside the scope and will be excluded. If you speak out of turn or introduce excluded topics, I will give a warning, and continued disruption may result in your testimony being limited or excluded under 287. Prior to this hearing, we've had multiple motions filed by both sides. Motions that were denied remain denied. Motions beyond the jurisdiction of this division will not be revisited. Employer-insurer's motion for sanctions, as previously described in the order, will be taken under advisement and will be ruled upon in the final award. All exhibits must have been exchanged through the evidence Dropbox by discovery deadline. Documents not timely submitted or not provided by two opposing counsel will be excluded. If If a party claims a document was submitted improperly or attached to a motion, I may allow the record to be opened briefly pursuant to my statutory authority, but only for relevant and previously disclosed evidence. Ms. Jordan previously stated that there is a doctor's report that is attached to the end of a motion, and I will allow 5 business days following the conclusion of the hearing today for it to be uploaded and exchanged. If that does not happen, it will not be admitted, and the record will close. We will now proceed to the presentation of evidence. Ms. Jordan, proof. You have been sworn in. Please restrict your testimony to the right individual. Do not testify about other claims, personal grievances, or legal issues.
At this time, I would like to tell the judge that I would like to leave. I'm under the weather. I don't feel good, and my body is hurting, so I would like to leave.
Claimant has asked that this hearing has been delayed. This hearing has been delayed. This claim is 3 years old. It has been stale, and pursuant to the use of the resources of this division, the request is denied. We will get through evidence.
Can I go to the bathroom, please?
We will take a recess, of course, to use the restroom.
I understand, but you have to do it now.
Are you leaving?
I'm going to the bathroom. You know where the bathroom's at?
Yeah, right here.
Okay.